59 of At Your Service with Haber and Martinez. I'm Haber. Martinez is not here today. He may pop in if we get lucky. We'd love to have him. And if not, then it'll be a conversation between myself and the gentleman sitting to my left, Barry Wack.
What's happening, Michael?
Barry is a local attorney. He's a preeminent, prominent criminal defense lawyer here in South Florida who cut his teeth at the public defender's office, did his 3 years and never looked back. Barry handles all sorts of federal matters and state court matters. One of the things I love about Barry, there's so many things to love about Barry, but one of the things I love about Barry is that even though he swims in very deep waters with very big fish, he loves to jump into little ponds and handle DUI cases and DB cases. He's not too proud to come back into the trenches and join the rest of us in the real world. But when he's not doing that, he's handling very high-end fraud cases, whether it's insurance fraud, Medicare fraud, tax fraud, conspiracy, money laundering, drug trafficking cases, state and federal court. And he has developed a niche area with regards to administrative law. And that's what we're going to be talking about today. The title of today's show is The Intersection of Criminal and Administrative Law, Representing Folks with Professional Licenses. So the reason that we kind of came up with this is that Barry and I were yapping not too long ago, and this topic came up, and I didn't know how entrenched he was into this area of the law. And one of the things that we do as criminal lawyers is we have to be very alert and attuned to collateral consequences in our cases. We've done many shows on collateral consequences, and one of the shows that we did was a show that we called Crimigation, which was the intersection of immigration law and criminal law. And the reason that comes up a lot is because you have a lot of people who are here on visas or here illegally, and then all of a sudden they've got an INS problem when it started as only a small criminal matter or a large one. Well, the same can be said of administrative issues and licensing issues. And with that, Barry, thank you so much for coming. I appreciate your letting me yammer for a minute or two here.
My pleasure. Anything for you, Michael. I'm looking forward to a great show today.
So, you know, we come across this a lot, right? And it's a wide swath because I actually tried to Google and figure out how many different regulative administrative or administratory boards we have here in the state of Florida. I can't even get a definitive answer. There are dozens, if not hundreds, of different boards.
Yeah, it's crazy, and everyone has their own rules and regulations, and so you know, you try to get a handle. A lot of them in the state of Florida, especially, are pretty harmonized in terms of things like if you have to report an arrest, if you have to report a conviction, the timing, the procedures for challenging them. But at the end of the day, it's impossible to memorize all of them. And I'm always making reference to the statutes. Plus, you know, we have a pretty active legislature, if you haven't noticed, in the state of Florida. And if something happens that our governor doesn't like or the legislature doesn't like, there tends to be a pretty rapid change in the law. So you try to stay on top of it. But yeah, it's an alphabet soup. It really is.
So you have, you know, people maybe don't know how profound and proficient these licenses are. I mean, many people are aware of things, you know, just because it's what we do, right? You know, so if you're a lawyer, you have to get licensed by the Florida Bar, and if you're a doctor, you have to get licensed by the Board of Medicine, and if you're a teacher, you have to get licensed by the Board of Education. But you have to get licensed to do damn near anything in the state.
Absolutely. I mean, you want to be a massage therapist, not only do you have to be licensed, you know, you have to go to an accredited school. I just spoke to someone today who called, that found me on the internet and said, you know, I have a misdemeanor conviction from 2015 and I want to become a health insurance agent. And I want to know before I even start paying for all the fees, am I going to be able to get a license, or I'm just going to be throwing money away? And it really covers, it's just such a broad spectrum of things. And so it, you know, before you start operating, before you start doing anything, you really do need to check and see if you need a license. I mean, hell, you want to go get a manicure and a pedicure, those people have to be
Esthetician,
licensed as well. Yeah.
right?
I mean, we see the foot massage places opening all over town, especially up in the north end of the county. And, I walked into one this weekend. I'm not ashamed to say I went and got my feet massaged. And I mean, the board of everybody in there had a license on the board. And I was happy to see that they were licensed at least.
So my question is, do the little fish that swim around there and eat the stuff off your feet, do they have to be licensed also?
Well, you got to pay a little extra for that apparently. So, I didn't find out, but yeah, I'm sure they had that bowl in the back somewhere.
So yeah, I mean, it's estheticians, but
Mm-hmm.
pretty much, I mean, across the board, if you want to do garbage disposal, if you want to be a handyman,
Sure.
if you want to
Mm-hmm.
virtually any aspect of life. Now, that doesn't mean that everybody is licensed. Of course, that subjects you to criminal arrest and prosecution if you are supposed to be licensed and you're not, right? Practicing in a certain field without a license is itself a violation.
Yeah, well, like the big favorite here in Miami-Dade County is no surprise is unlicensed contracting. And you'd be surprised how many people skirt that particular licensing requirement and work under other people's licenses, which jeopardizes not only them, but also the licensee who actually holds the license. It's amazing how many people are willing to cut corners. And it's like that old Fram oil filter commercial. You can pay me now or you can pay me later, because they're going to get you one way or the other. So
speaking of now or later, it's some people have these issues before they get licensed. And then
absolutely.
some people, I think in my experience, the vast majority of people that I deal with, of course, this is not an area that I traditionally practice in, but the vast majority of people I deal with are people who come to me after they've been arrested, and I identify the problem that they're going to have. A great example, and this is a recurring example. If you have a concealed weapons permit in the state of Florida and you get arrested for any felony charge, you're going to get a letter, or at least you should get a letter from the Florida Department of Agriculture telling you your CWP is suspended until that case is resolved.
Yeah, 100%. And Michael, it also extends to misdemeanors. I see it quite frequently. In the intro, you mentioned that
in BVs.
Yeah, in domestic violence, we see it. Also in simple battery, you'll see it. You'll see it sometimes even in DUI cases. It really does depend.
So in those types of instances, that's somebody who's arrested and now develops this collateral problem as ancillary to the criminal case.
Absolutely.
But then there's the other type of folks, and those are the ones that I suspect that you're really able to help a lot more than I am. And those are the types of folks who want to be licensed. So let's take probably what I can think of as the plainest, easiest, basic example for me, and hopefully folks can relate it to their own orbits. But people who want to become lawyers, you may have had a problem when you were a juvenile, or, for myself, I mean, I had a problem because I got arrested for a misdemeanor in the summer, in between the time that I graduated college and started law school. So 3 years later, I had to report that incident to the bar, and it had to be dealt with. So the criminal case was long since closed over, dismissed, expunged, no issue, yet I still had to deal with that with the bar. So if you're an applicant for a license, this is a great area for you to be able to assist with, right?
Right. So let me speak to that, because you've been a lawyer now for quite a while, and the rules have changed, and specifically with respect to lawyers who might be listening to the show today, and law students, because all too often law students' admission to the Florida bar gets held up, not just because they had an arrest in the past, but because they failed to disclose an arrest or a disposition on their law school application. So when I was getting ready to become a member of the bar, I didn't submit my character application until after I graduated. Now they encourage law students, and in fact, most law schools require the students to fill out the background check application in their first year of law school, because they anticipate there's going to be these problems. So when these people submit their applications, it goes to the Florida Board of Bar Examiners, who basically vets them and does an investigation. So taking a law student or an applicant to the bar, and they'll say, do you have a criminal background? And people forget. I mean, obviously, you've had clients who come to you who can't even recount their prior record to you, much less the lawyer who represented them. So the Florida Board of Bar Examiners will send a letter to them that says, hey, you failed to disclose this on your law school application. We want to know why you didn't disclose it. We want to know what happened. And by the way, you're going to have to appear in front of us for a hearing before three very harsh individuals to try and see if that arrest that you had for having an open container of beer when you were 19 years old in your second year of college is going to keep you getting into the Florida bar. It's crazy. And now you get into a completely different scenario with people who are already in the bar and have been arrested. That's also another problematic area for lawyers, because the Florida bar is probably one of the most difficult, harsh agencies in the entire state of Florida to deal with when it comes to criminal matters.
But the same would hold true, again, regardless of where your licensing falls, right? So if you're a school teacher, you're going to wind up in front of the Department of Education or the Board of Education. Either, again, you're applying for your teaching certificate and you have disclosed something or have failed to disclose something that they found, in which case odds are you're going to be called in to answer for it, or you're a licensed Department of Education employee, individual, and now you pick up some new incident in your life that winds up, putting you in front of that board with regards to your pending license.
Sure. And, this is where you said there's a whole alphabet soup of agencies and every one of them are different. So take, for example, a doctor. So let's suppose a doctor gets arrested for a felony charge, like let's say Medicare fraud, a very serious federal charge, or even something like domestic violence. The Board of Medicine does not require a report of your arrest unless you're found guilty of the crime, regardless of whether you've been adjudicated guilty or convicted or withhold of adjudication.
I don't mean to cut you off, but just to be clear so that the audience understands, we're specifically talking about doctors and the Board of Medicine. This is not generic across the board. There are other agencies that require you to report certain arrests. There are some that require you to report only felony arrests. It just varies.
Correct. Yes, absolutely correct. So, for example, take a teacher. Teachers are a different breed because teachers now are dealing with minors, with children. And so, oddly enough, you'd think that doctors would have to report things prior to disposition. They don't. Teachers, in many instances, do.
And lawyers as well.
Well, lawyers have to report a felony arrest within 10 days of their arrest. They don't have to report a misdemeanor arrest until disposition. So it's very interesting. Now, bear in mind, though, that a state attorney, a prosecutor, or a federal prosecutor are subject to the rules regulating the Florida bar. And those rules say that a state attorney has an obligation to report cases to the bar or to other boards. So even though you might not have a reporting requirement, that might get reported by a prosecutor. Or if the media is covering your case and it shows up on the news, regardless of reporting requirements, you might get an investigative letter from any of the agencies that license people saying, hey, we heard about this. Now you've got to respond to it. And the issue that comes into play there so many times, Michael, is that people get these investigative letters from their licensing boards, and they make the mistake of responding to them themselves. And they don't think to themselves, hey, I think I should get a lawyer to do this. Funny story, the way I got into doing this was because I was asked probably close to 30 years ago to represent a lawyer who was a friend of mine who had gotten a bar complaint. And he had been retained to represent someone on a traffic ticket. And the person didn't get the result that they wanted on the traffic ticket. I mean, they might have had to go to traffic school and do a little more than just pay court costs, or maybe they got points on their license. I don't remember. And the lawyer responded to it themselves, and they wrote a letter back to the Florida bar that said, you know, I went to court, I had the hearing, the judge found this person guilty, this is the decision the judge made, they imposed the sentence. I told the person all of these things. And the person had represented in their complaint to the Florida bar that the lawyer promised them in their meeting that he was going to keep points off of their license and they weren't going to have to go to traffic school. And the lawyer, in responding to the letter himself, wrote, and by the way, I never even met with this person before I went to court, so I couldn't have told him that thing.
Oh,
well, yes, when he brings the case to me, it's because the Florida bar said, you know, it's okay that they didn't get the result that they wanted. That's fine.
you didn't
But
communicate.
you cannot go to court and represent someone without meeting with them and finding out about their case. And now he had a real problem on his hands. We were able to take care of it, but that happens all too often. And
Yeah,
I see, yeah. So go ahead, Michael. So
no, it's just going to follow in with the lawyer thing because, you know, I assume that there's probably at least a few lawyers out there watching. You know, you have the bar is so brutal. And one of the reasons that we are considered, or it is considered, it's not a we thing because apart from being licensed, I don't have any other, you know, connection to the bar, but
right.
The bar regulates not only how lawyers practice law, but they regulate every freaking aspect of your life.
Oh, yeah.
If they don't, if somebody files a complaint against you, you don't have to be arrested. You don't have to commit malpractice. You don't have to even represent an individual. But if somebody rats you out to the bar, for lack of a better term, for whatever reasons, oh, I know this lawyer that, you know, goes out and drinks himself stupid and gets on tables, starts dancing, you know, or, you know, made racial slurs or whatever they want to come up with. That's enough to get the bar to crawl up a lawyer's ass with a microscope, right?
No question. You know, there's a provision in the Florida bar rules that says that you are governed in all of your professional activities, but the bar has also taken a real interest in what we call professionalism over the last 10, 15 years. And so when lawyers do act inappropriately and complaints are filed against them, the bar definitely takes an interest. And I think that this is an area that people need to recognize, especially lawyers who aren't practicing law. A lawyer might be a realtor and share a referral fee with a non-realtor, which is against the real estate rules that they're governed by. And they might get a complaint with the Florida bar for failing to follow the real estate rules, and they'll get disciplined by the Florida bar. And I think the reason I had told the anecdote about the lawyer early on is just to show if lawyers don't know what the rules are, how can we expect non-lawyers to know what the rules are? And so, you know, you get back to the licensing you brought up earlier about the concealed weapons permit, where upon arrest, you're going to get a letter from the Department of Agriculture. And you know that letter, Michael, and I know that letter.
Yep.
And what it says is your license has been suspended and send it to us, mail it back to us. So my clients who come in who have concealed weapons permits and say, hey, Barry, I got this letter. What do? I say to them, give me the letter. I take the letter. I write back to the Department of Agriculture and I write back and I say, look, the client is currently awaiting, you know, the resolution of this case. Right now, they get the presumption of innocence. And I'm going to hold on to their license, or they're going to hold on to their license. We're not going to turn it in just yet, and we'll let you know at the outcome of the case. And if the outcome of the case means that they have to turn in their license, we'll turn it in. And I've never gotten a letter back saying, oh, no, you have to send us the license now. It's never once happened.
I agree. I do the same exact thing. I've never gotten any, in fact, I've never gotten any response at all from the Department of Agriculture, but I keep a copy of the letter, and that's it. It's in the client's file. I mean, I actually have, crazy as it is, I probably have a half a dozen CWPs from old clients that never bothered to get them back.
Never came back and got them right. You know, it's very interesting too. And the reason I think that it's good for people to understand something as simple as that is when you go through the administrative licensing process and you get a letter from the licensing board, whether it's as an applicant or as someone who's already licensed who's seeking discipline, You know, the lawyers for the agencies, the people who are on the other side, you can pick up the phone and call them. You can write them letters. There's all sorts of options that become available to you when you've got licensing issues. The Florida bar is simple with lawyers who get arrested. The majority of those cases, you can get the Florida bar to hold it in abeyance or put it on what we call monitoring status, pending the outcome of the case. When it comes to other licensing agencies that say, well, we're going to deny you a license. Just because they say we're going to deny you a license doesn't mean that they're entitled to deny you a license. So you pick up the phone and you call the attorney for the agency and say, listen, I know we're entitled to a formal hearing or an informal hearing, but here's a case and here's the law that basically says if a person's record has been sealed, they might have to disclose it to you, but you can't use it as a basis to refuse them a license. And the law is very clear, but a lot of times they send a denial anyway, and they say most of the people aren't going to know the difference, and they're going to think they can't be licensed when a simple phone call gets them their license.
You brought up a whole swath of different topics that we can talk
Right.
about in that
Right.
one little diversion.
Mm-hmm.
I guess let's jump with one of the last things that you said: formal versus informal.
Right.
In my experience, and again, one of the departments that I deal with regularly with regards to administrative components is Department of Highway Safety and Motor Vehicles.
Right.
I do a lot of DUI work, and anybody who gets a DUI, if they either refuse or blow over the legal limit, gets an automatic suspension of their driver's license. And that implicates an administrative process that works completely independent of the court process.
Correct.
And it's a whole different ballgame. You're in front of a glorified, possibly retired Florida Highway Patrol officer wearing a polo shirt, who's bound by the administrative code as opposed to any statute or constitution. And there are no provisions. And so actually, before we go to formal versus informal, let's talk a little bit about the difference between rights and privileges, because I think that's really what the distinction, probably the best way to distinguish criminal administrative law is. Criminal law is rife with rights, whereas administrative law is all about privileges. You have very few rights, if any, with regards to administrative proceeding, right? Even many of them won't even allow you to have a lawyer.
That's very true. A perfect example of that is a college honor council when they're overseeing the students. If the students have problems on campus or off campus, they don't really want lawyers to get involved. Or, there's many others that are like that. I know the Florida Board of Bar Examiners jumps to mind. But yes, a license for anything, whether it's a driver's license or a license to be a doctor or a veterinarian or what have you, or a lawyer, that's a privilege that's granted to you by the state, typically, or the federal government. And the privilege is extended to you because you qualify. You've passed a background check, you've shown a certain level of proficiency, and you meet all of the necessary requirements, you've paid all the fees, and we're going to give you a license as a privilege. I think the DUI scenario is really something that we come across as criminal defense lawyers all the time. And it's very interesting because I'm sure you know this, and many of the lawyers listening might know, but on your driver's license, in very, very small, tiny writing, right below your picture, typically, it says, the conferral of this driver's license upon an individual is considered as consent to submit to alcohol, to blood testing to determine the alcohol content of your blood. And I think that's in, like, what is it, Michael, 2-point type?
It is there. It's not as long a statement as you just gave, but that basically says possession of this license, acceptance of this license constitutes your agreeability to submit to law enforcement testing. But what's interesting, and I just want to make one quick point about that, even though it's not really on point to our topic, but because we're talking a little bit about DUIs, I want to make sure people know. In order for them to remove the privilege, you are entitled to due process. Now, you may not have the same rights like you do in a courtroom when you're accused of a crime, right? You can't go in and plead the fifth. You're not entitled to a lawyer as a matter of the sixth. You're not required to have a judge scour a search warrant before it's issued, per the fourth. But you do have certain rights, and they are due process rights. So they can't just necessarily strip you. But the thing I want to get across on DUI is, just so you guys know, we have a law in Florida called implied consent. And that means that even though your privilege will be taken from you, they have to first tell you that. So in other words, they can't just take your driver's license and say, no, too bad, so sad, now you lost it.
Right.
They have to first tell you and actually read you and have you sign a form called implied consent, where they tell you the law, that when you got your license, you agreed to take this test. We can't force you to take it. We can't compel you to take it. You have a right not to take it, but here's the consequence. It's called a suspension. Now, that implied consent law, and this is the point that I wanted to make, because I think most people do know that, but what you probably don't know, or may know, but if you don't, this is good information. That rule does not apply. There is no implied consent to field sobriety tests. So when the officer asks you to step out of your vehicle and take a series of tests that are abnormal tests designed to predict your normal faculties, there is no implied consent. They don't have to tell you that you have a right to say no.
Right.
Even
And
though
that's,
you do.
yes, and that's correct. And, we could probably spend 3 episodes talking about the DUI exceptions to the United States Constitution. But I suspect that we'd lose a lot of people. But,
Most people don't know that. So
yes, but Michael, what you bring up about DUI, those DUI hearings, is true. You said a retired FHP officer wearing a polo shirt, and you get back to informal versus formal hearings. Many times the hearing officers that conduct these hearings for the administrative agencies are not lawyers. They're
almost never lawyers.
They are not.
I mean, except for the Florida bar.
Right, but many times you run into this in scenarios that can have a very significant effect on what ultimately happens in the case. In the administrative law process, for example, let's say if you're a public adjuster, we'll go back over to contracting and that whole area. Let's say you're a public adjuster and you have a prior criminal record from, 10 or 15 years ago, and they deny you a license based on your criminal record, and perhaps also for failing to disclose your criminal record. Well, you're not contesting the facts of why they're denying you a license. What you're trying to do is say, yes, this happened, I failed to disclose it, yes, I was convicted, but I should have a license anyway because. And that, if that's the case, you're going to ask for an informal hearing, because an informal hearing is like a motion argument in court. You don't take testimony. There's no witnesses. There's no evidence that's presented. You basically agree on the facts, but you just want the hearing officer to rule yay or nay in terms of getting you a license, or reinstating your license, or not disciplining you. If, however, you're being denied a license or disciplinary action is being sought by an administrative agency and you contest the facts, well, now you're entitled to what's called a formal hearing. And a formal hearing takes place in front of an administrative law judge, which is part of the Division of Administrative Hearings. So the licensing agency has to request from the Division of Administrative Hearings to open a case file and to assign a judge. And then at that point, you're moving forward just like as if it was a court hearing. And so you're entitled at that point to what we call discovery. You can, request production of documents. You can take depositions of witnesses. And ultimately, you're working towards a full-blown trial. And I've handled those on several occasions. And I will tell you that in many cases, it's in the client's best interest to go to those administrative hearings, because the departments don't do a lot of these trials. A very small percentage of cases go to these trials. So an experienced trial lawyer like you or I, we have quite an advantage over a lot of these agency lawyers when it comes down to trying these cases.
So when you were talking about how a lot of times they're not lawyers, and we were talking students in schools, I had one not too long ago where I had a student at FIU who had gotten arrested on campus for a narcotics offense. and he was administratively suspended from school and, of course, prosecuted criminally. And then he got called in to the honor board at school, and he had to answer to them. And I helped him through this process. And you had said something that was really interesting, and I made a note of it, that they're usually not lawyers that handle these issues on the administrative end. And in this case, it was a graduate student who was serving as the liaison. He was kind of the go-between, right? So you were dealing with this grad student in an effort to try and resolve the matter without having to convene the entire board and go through a more formal process. And I think one of the reasons that they don't let lawyers, they specifically write lawyers out of the rules, because in that case, I was permitted to be present, but I was not permitted to speak. So it's kind of like a grand jury proceeding. Although I was allowed in the room, I didn't have to wait outside. But if the student wanted to ask me a question, he had to ask, not me, he had to ask for a break, and then we could step outside and talk. Now, those were the rules, and they were a little informally enforced because everybody was more, kumbaya leveled. We were all trying to work towards the same end. But I did find it interesting to make that connection, that I think one of the reasons they don't want lawyers involved is because there's a much better chance of resolving it between the parties quickly and easily. When you throw a lawyer in the mix, it tends to complicate matters because of the way that we are trained to proceed.
Right. And that really is, I think, one of the best takeaways, overall, regardless of the type of administrative proceeding you're going in, that anybody can take away from this session today is it's all about trying to get the right resolution. It's all about, for a student, for instance, making sure they get to stay in school. For a doctor, that they can keep practicing medicine. For a teacher, that they don't get removed from the classroom. And so rather than trying to come on gangbusters like you might in a full-blown, prosecution for a serious crime, where you're all of a sudden filing motions and having hearings and taking depositions and investigating the case and interviewing witnesses, sometimes you want to just take a step back and say, okay, what's our goal here? And how are we going to get to that goal as expeditiously, as effectively as possible? And I think that the school scenario that you just established is really emblematic of one of the best ways that you can handle these cases. Go in with honey, not vinegar. Talk about what you want. It might very well be the same thing that the school or the agency is looking for.
The other thing that you need to bear in mind when you're the person on the line, whether it's a professional license, academic, whatever it is, one of the benefits of running through this with a lawyer who understands it is preparing you, because you're the one on the hot seat. So I think Barry would probably agree with me. One of the things that keeps us up at night as criminal litigators is the thought of our clients testifying. It is a very, very rare client, and there are some. I've had a few. I know you've had a few. There are some clients that you have great confidence in their ability to tell their story and stand up to cross-examination and follow the path as you lay it out, the script as it may be. But the overwhelming majority, the hands down odds are we hate it when our clients want to take the witness stand, because it's just a recipe for disaster. And I think you can apply that same logic to this. We are able, or in this case, Barry would be able to assist you to understand the dynamics of things that you are going to want to focus on, the things that are going to be more important for the board to hear, things you might want to avoid or minimize, things that you definitely need to be on the lookout for and be prepared for, because there are some zingers that will come at you when you're on, in the witness seat, whether it's a courtroom or an administrative proceeding or an academic review board or what have you. There are zingers that are going to come at you, gotcha questions. And those are the types of things that we may be able to help you so that you don't implode like one of our, headstrong and who insist on taking the witness.
Yeah, you know,
right?
Michael, it's so true. We as human beings are naturally defensive. It's in our DNA. I think it goes back to the days of cavemen when we were running away from animals trying to save our own lives. And it really
Or
does
running away from
translate.
cave women trying to save our own lives.
Exactly. So, it's human nature. So, like take the earlier story I told about the lawyer who wrote down, and I never met with that person. So how could I have said that to them? They're defending themselves, and sometimes defending yourself means that things come out of your mouth that are going to hurt you more than they're going to help you. It's like when you tell a defendant who's your client who wants to testify, you say, listen, that prosecutor's educated, they're intelligent, they're sharp, they know what they're doing, they're going to get your goat. Don't argue with the prosecutor, and don't feel like you have to argue every single point. There's things that you can concede, there's things you can give up. They make you look better. But people can't wrap their head around that, and they want to defend themselves. And again, the things that just come out of their mouth, you just turn to yourself. You have to sit there stoically and not show you have to play poker as best you can, but in your mind you're going, oh Jesus Christ, how could
And
you
and
say that?
sometimes the smarter that you are, or the smarter that you think you
Oh, the
are.
worse it is. Yeah.
So,
Mhm.
lawyers are, like doctors always say that doctors are the worst patients, lawyers are the worst clients, because
Very difficult.
we don't want to be told anything.
Right.
But one of the things I want to mention, and we kind of do this in the show, it's a running theme. I like to call them pro tips that we're giving our listeners, and you've already thrown one out there. The pro tip of trying to get the right result, right?
Right.
Focus on your end game, and that's how you make your strategy and your game plan, right? So I think there are a couple other pro tips, that certainly more other pro tips we can throw out, but one that we just hit on, which is boilerplate good advice. And even though Abe Lincoln didn't actually make the quote, he gets credit for it, right? He who represents himself as a fool for a client. It dates back several hundred years before Honest Abe was born, but that's another story for another day. But the point is very relevant and true. Even most lawyers will tell you, even on simple things, if I get a traffic ticket, I don't represent myself on the traffic ticket. I'm perfectly capable of handling my own traffic ticket. It's really not a problem. But the truth is, the cop gave me that ticket. I'm not going to do myself any favors. If I couldn't talk my way out of the ticket on the side of the road, I'm probably going
Exactly.
to bury myself further in the courtroom. It's better to have Barry, or even the ticket clinic, whoever, go in there and handle it, so that you've got some neutral, unattached, unemotionally involved individual handling the case. So I think that would be another pro tip that we could throw out here. Barry touched on that earlier. When you get that letter from, DBPR, is that what it is?
Yeah. Yeah.
Yeah, when you get that letter from DBPR, don't respond to it yourself. Sit down with somebody who knows what they're doing and get good advice. If you are going to respond to it yourself, make sure it's only after you've spoken to someone who's counseled you on the right way to do it. Because it may be that it is in your best interest to not have a lawyer do that response. It may be in your best interest for it to be on your own letterhead, but that doesn't mean you should be the person crafting the language.
100%, Michael. And it's another, I guess, so-called pro tip, that we can throw out there is responding to an email, for example. And this doesn't even have to be in the context of law or administrative issues. It's just somebody writes you an email and you write back an angry response to them, and then the next thing you know, they're filing a bar complaint, or
Or a
maybe it's as
restraining order.
simple, or a restraining order, or maybe it's just as simple as contacting your employer and saying, hey, your employee wrote this back to me and said this to me. And I always tell people it's okay to write that email, but
Just
just
don't
leave it
send.
in your draft. Don't send it. Leave it in your drafts folder for a day. Maybe, just go back and look at it a day later. And if you still want to send it, run it past someone before you send
I,
it.
I always say handwrite it, because that
Yeah,
way it's
even
not going
better.
anywhere, and you can always transcribe it electronically if you wish. But
Yeah, and most people can't even read their own handwriting anyway, so you'll forget what you wrote.
right, and you and I
So,
both have teenage kids right now, so they can't even
yeah,
write. Um,
cursive? What,
yeah,
cursive? Huh?
especially thank you cards.
Yeah,
Um,
unheard of.
while we're on that subject that we just touched on, let's talk about restraining orders, because
Hmm.
that's a really big issue in the administrative arena for
Sure.
several
Hmm.
reasons.
Yeah.
One, if you have a concealed weapons permit and you get a temporary restraining order served on you for domestic violence, for stalking
Right.
violence, any of the DV type restraining orders result in an
Mhm.
automatic suspension of your concealed weapons permit and a court order that you have to surrender any firearm that you own. You're supposed to
Mhm.
surrender them to a police station. Again, I don't know whether Barry does this, but I will routinely, as a courtesy for some clients, I will accept and hold their firearms for them. We'll maintain a list, and then I will file an affidavit with the court advising them they were not surrendered to law enforcement, that I have them in my care and custody pending resolution of the case. And if the court wishes, I will, make sure they get to a police agency, but we prefer to keep it this way. Most judges are cool with that.
Mhm.
That's one way that these things can affect you, but another way that they can affect you is with regards to licensing. So a lot of boards will pull you just for a domestic violence issue. You can have a problem just based on that allegation. Big
Yeah.
problems, not only with defending the DV or stalking or sexual violence or repeat violence or whatever it may be. Not only defending that substantively, but collaterally with regards to if you have a pending application for a license or if you have a current license, and certainly
Yeah.
if you have a concealed weapons permit or
Mhm.
firearms.
Yeah, no question about it. It's odd. Domestic violence, for the most part, is a misdemeanor offense. There are felony domestic violences, of course, in Florida, domestic violence by strangulation, or of course, other crimes can come out of that. But your typical domestic violence, whether it's a punch or a slap or a kick or a push or whatever, throwing water on someone, is a misdemeanor offense. And typically, misdemeanors don't have significant consequences. I think domestic violence is one of the few that does. And when it comes to your Second Amendment rights, they certainly do implicate your right to possess a firearm. Because remember, when it comes to a crime, you do carry the presumption of innocence. And you have to see that the courts, the legislatures are basically balancing your right to possess a firearm next to perhaps, maybe this is not a great description, but your propensity for violence. And so the idea is we want to take the guns out of your hands so that you don't go and kill your domestic partner or your spouse or a family member or whoever it might be. Possession of a firearm while subject to a domestic violence injunction is a federal offense. It is a serious federal offense, and I've had to defend that charge.
And just to clarify that, what Barry's talking about is, as a state matter, you are subjected to a state prosecution. But possession of a firearm while being subject to that state prosecution is a federal offense.
Exactly. And so, it's because guns travel in interstate commerce and they can extend federal jurisdiction over it. But, the most difficult thing about those is you can't defend those cases by saying, well, the injunction should never have been issued in the first place. You can't go
It's,
back and do that.
it's a technical violation.
It is a hyper technical violation. Now, interestingly enough, I believe it was Texas, a court out of Texas recently, and I haven't read the opinion, but I did look at the summary of it, held that crime was a violation of the Second Amendment, that you could not prohibit someone from possessing a firearm because a domestic violence restraining order is a civil matter. It's not a criminal matter. And of course, the rules are different for criminal and civil. Agency licensing matters, by the way, even if they're based on criminal offenses, are civil matters. And as you mentioned earlier, Michael, you don't necessarily have a Fifth Amendment right to remain silent because, again, and this ties it all together, your license is a privilege. It's not a right.
And in regards to the domestic violence context, just to make that point very clear, a lot of times somebody will get arrested for a misdemeanor domestic violence case, which on its face is a low-level criminal offense. However, for that person, it may as well be a murder rap.
Oh,
So
yeah.
in criminal court, in that criminal prosecution, you have the full panoply of constitutional rights. Now, that same person may wind up getting served with a civil domestic violence restraining order because the victim in the criminal case goes to civil court and applies to a judge and says, woe is me, look at all the bad things this person did, I need your help. And then they get served with you get served with a civil injunction on top of it. Now, you've got two separate cases. You've got a civil injunction and a criminal prosecution. They're going to be in front of two different judges with two different sets of rules of procedure, different evidentiary predicates, different burdens of proof. And in that particular context, if your civil judge is impatient and intemperate, they could actually force your civil case to trial before your criminal case, and you have no Fifth Amendment privilege in civil court. Now, you can sit there and invoke the Fifth and refuse to answer the questions, but then that civil judge is entitled to make a presumption against you because you invoked your Fifth Amendment privilege. So
Right.
it's just a horrible situation, and I would assume that the same applies administratively.
It does. And, you know, as you put it, they make a presumption. It's actually called an adverse inference. So
Thank
the
you.
inference is if you invoke your Fifth Amendment right, you would incriminate yourself by admitting to the crime. And
Ironically, that's the exact opposite of what's allowed in criminal court, right? If a
correct.
prosecutor makes that argument, it's a mistrial.
Exactly. And, you know, interestingly enough, the chances are that the restraining order is going to come to a resolution well in advance of the criminal charge, because we know the criminal courts are absolutely overcrowded, as are the civil courts, but the criminal courts are entirely overburdened. And you can, you know, misdemeanor cases, domestic violence and a criminal conviction are very significant, obviously. And so that might take quite a while to even come to resolution, can take a year or more, even if it's a misdemeanor. The civil injunctions, the statute even says this has to be disposed of as quickly as possible. And so the judges, when you get the restraining order, which originally is a ex parte, meaning just the complainant goes in and files the restraining order against you and you don't get a chance to be heard, it gets issued and then it gets set for a hearing in about 2 weeks. Well, that's not a full-blown hearing. You know, that's just a judge saying, okay, do you want a full-blown hearing? And they set that off in the future. But, you know, it's a dichotomy that you have to deal with, and that can really alter your life, because unfortunately, we're a very harsh, unforgiving society these days. And an allegation of domestic violence can result in you being basically fired from your job. You know, many employers, their human resources policies require that you report an arrest to them, and they're going to take action on you before the courts are going to do anything.
Barry, what about, do you represent public employees? I've had several clients that were firefighters and a few police officers who have hired me on criminal matters. In all of those instances, those individuals had to deal with discipline by their own agencies. I've never done a hearing in front of a police or a fire agency. I always make sure that that individual gets a hold of their union rep, because they're much more familiar with the rules and the protocols and procedures, and I offer to assist in any way that I can in terms of providing information and evidence, defense investigation, sharing of information. But I don't know if you've ever handled any of those types of administrative hearings.
I have, Michael, and it's not just police and firefighters. Teachers, believe it or not, have the same benefits that those agencies do as well. The shop steward or the union representative is the person that must be contacted immediately. On the federal level, I've dealt with it with people who work for TSA or baggage handlers, or anyone who's working at the airports, whether it might be your customs clearance to go out on the ramp. You've got to get in touch with the shop steward and talk to them first. You also have levels of review with those agencies as well. It's a little more, it's a highly technical area. For example, if you have a problem at the airport, if you're an airport employee or a port worker or somebody, the ultimate individual who's going to determine it is the port director. And most of that is done in writing. And you've got to maneuver through that. But police and firefighters, for that matter, they have their interagency discipline. For example, you might be suspended with pay. You might be suspended without pay. You might be confined to your home during work hours while all of this is pending. for police officers, their union, at least here in South Florida, appoints a lawyer to represent them. Many of our colleagues who are former prosecutors and criminal defense lawyers now get appointed regularly to represent those individuals in front of their board. And then they have their avenues of appeal that go all the way up to the Florida Department of Law Enforcement. So, ultimately, at some point, you're going to deal interagency, and then you're going to go to the next level, which is statewide agency with those people.
Just so the folks know, this really is complex stuff. It gets really deep. It's like an onion. The layers really can have to be peeled back. So much so that I don't know if I mentioned this or not in our intro, but Barry is a past president of our local chapter of the Florida Association of Criminal Defense Lawyers, and he's also a director of the statewide organization. Here locally, I don't know, we have maybe 800, 1,000 members in our local chapter. It's a pretty big and active chapter, and we have a mailing thing through Google where we can communicate with anybody who subscribes. There are hundreds of lawyers on it. And routinely we get emails of lawyers that are looking for referrals for somebody in some other, location, Wichita, Kansas. Does anyone know a lawyer there? Or somebody who's looking, for information on a particular prosecutor or judge or detective. There's a lot of information sharing. There's also a lot of idiotic, ridiculous banter, but that's another side issue.
Another story.
The reason I bring it up is because just last week, and I'm going to, leave out the specifics so that nobody's identified, but somebody actually posted, this is an actual request from one of our local criminal defense lawyers to the group. I have a client who was recently indicted on federal charges in DC. He's a helicopter pilot, ex-Army warrant officer. He works for a private contractor as a pilot, or so he did. He just received a letter from the FAA that his pilot's license has been revoked on, quote, suspicion of terrorism and piracy. Has anyone appealed administratively or dealt with the FAA on license revocations relative to these types of criminal allegations? So, there you have it. This is a lawyer who's apparently skilled and competent enough to have a client in that capacity reach out to them, which, you're not talking about somebody who just walked out of law school getting a case like that, right?
Exactly.
Yet that lawyer is looking for advice as to how to deal with this type of a situation.
Yeah, this is a very esoteric field of law. Most lawyers aren't even sensitive to it. I interview individuals charged with crimes all the time, and I do a pretty extensive interview first time with people, and I like to find out about their backgrounds. And when I find out that they hold a professional license, one of the things that I address is the consequences of the criminal investigation or prosecution on their licenses. And they say to me, wow, you're the first lawyer who brought that up. I've spoken to 3 or 4 other people and no one talked about that. And it's, no doubt it's a value add for me when I'm trying to persuade someone, in the interview process that I'm the perfect lawyer for them to hire. But that just shows how many lawyers aren't sensitive to it because it's not right in front of them. And so they don't see the consequence. I've always believed that, especially as criminal defense attorneys, we don't just represent the defendant, we represent their families. If someone's charged with a crime and they're looking at jail, there goes livelihood, and that could affect the family profoundly. It could mean they can't pay the bills. It could mean they get evicted from their home. It could mean, God forbid, that they become homeless or they have to rely on the generosity of family and friends to get them through it. So, I'm always sensitive to the consequences of someone landing in my office as a potential client beyond just the specter of incarceration or probation or supervision or surrender of firearms. It just gets so multifaceted. So when it comes to this licensing area, Michael, and I really do appreciate you inviting me to come on the show and talk about it. Hey, I hope that, it was funny when we were talking about the show, you even said to me, we'll have no trouble talking for an hour. And I see we pretty much almost used the time, and we could probably go on for another hour or two.
Well, there are a few more things I want to hit.
Okay.
I want to talk a little bit about expunging and sealing, because
Right.
that becomes a big problem with regards to particularly people who are first-time applicants. I mean, we could talk about law students, but it would be equally applicable to virtually any licensing board. So you get arrested for X, you get the resolution that you're looking for, either you're acquitted or the case gets dropped or you complete diversion. For some reason or another, the case goes away and you're able to expunge it and you're feeling great because there's no record, which is really not entirely true. As we know, these
No,
things,
it's not.
especially in the digital age,
Mm-hmm.
nothing ever really goes away. But still, you can pull it out of the public records, make it a lot more difficult to find in many cases. But what happens now when you have to disclose this and you think you don't have to, right? So you're applying to the Florida bar. Guess what? You've got to disclose, but not just the Florida bar. I'm going to read off a list from Florida Department of Law Enforcement's website. These are the entities entitled to access of sealed and expunged records. If you are a candidate for employment with a criminal justice agency, meaning any criminal justice agency, you've got to disclose sealed and expunged records. If you are a defendant in a criminal prosecution, you have to disclose sealed and expunged records. If you are concurrently or subsequently petitioning for relief for clemency, you have to disclose. If you're a candidate for admission to the bar, if you want to be employed or licensed with Department of Children and Family Services, Division of Vocational Rehab, Department of Education, Agency for Healthcare Administration, Agency for Persons with Disabilities, Department of Health, Department of Elderly Affairs, Department of Juvenile Justice, Department of Education. If you want to purchase a firearm from any manufacturer, importer, or dealer, if you want to be licensed by the Division of Insurance Agent or Agency Services, or any department within the Division of Financial Services, if you want to be appointed as a guardian, if you're seeking to be licensed by the Department of Agriculture and Consumer Services for a CWP, all those things you have to disclose the record that you sealed and expunged.
And you're not even done. You know, the statute, this is just state agencies, you know, it goes on forever and ever. The law says that you're entitled to legally deny ever having been charged with the crime, much less found guilty of the crime. But it's totally not the case any longer. Additionally, when you get arrested and you get fingerprinted, your fingerprints get transmitted to the FBI, the National Crime Information Center. And even if you seal or expunge your records, those records don't get sealed and expunged. They're always there. So if you're applying for a federal license, let's say you want to be a stockbroker, let's say you want to be a pilot, they've got your records and they're going to find them right away, which is one of the reasons that I always tell my clients, when you're filling out an application for anything, just call me and I'll tell you what to say. And 999 times out of 1,000, I will say, just disclose it anyway. Because the disclosure is not, the crime itself is not going to keep you from getting what you want, but the failure to disclose very well may. And so, you know, always err on the side of disclosure is my position. And it's been that way for a long, long time.
I agree completely. I think, you know, they always say honesty is the best policy. Sometimes it is, sometimes it isn't. But if you want to get licensed, the odds are they're going to find out. And it goes even further than that because these things come up in background checks when you're trying to take out loans or when you're trying to rent an apartment.
I hear Michael renting apartments is probably one of the biggest calls I get from clients I've had their records sealed or expunged, and they go, I thought this was gone and now they're not going to let me move into this apartment that I've spent months looking for and I can afford. And I say, hey, can't help you. There's nothing we can do. It's a private company. They're entitled to deny you. As long as it's not discriminatory, they're entitled to deny it. Terrible.
I think that we've hit virtually everything that I wanted to hit. The only thing we didn't really get to was I had talked about massage therapists who pick up prostitution charges and massage clients who have professional licenses that pick up solicitation charges. But I think we can let the audience use their imaginations on those. You know, as to the former, the massage therapist who gets popped for prostitution, she's going to have a problem with regards to her massage therapy license.
I'm thinking
a risk that you run. And on the flip side, the guy or gal who goes in to get the massage with the happy ending, if they get popped, the ending ain't going to be so happy after all, because not only are they going to have a criminal problem, but they're going to have a potential licensing problem as well.
Yeah, we saw what happened to Robert Kraft, but then again, ultimately he did come out on top, no pun intended.
Yes. Well, I think it was the most expensive massage in the history of massage.
Yeah, I think the takeaway from that
know
is
for a fact-
we can leave to their imagination
I understand that was a 7-digit fee on that case.
easily.
Yeah.
Easily. So
Barry, thank you so much for coming on. I hope that the audience got a lot out of this. I just want to recap 3 pro tips that we've definitely established. There may have been more, but the first pro tip is don't go if you have a licensing issue, whether it's seeking a license or defending a license. Don't presume to go it alone. Maybe you will wind up doing it on your own, but only after you speak to someone like Barry, who can give you really good, sage, competent advice and steer you so that you don't compound your issues by making a foolhardy response. Dovetailing into pro tip number 2, don't self-represent. You're always better having a trained, licensed, skilled, bonded, insured lawyer doing this for you. You know, it's kind of like hiring some guy, your buddy's friend to come do your plumbing in your house, and then all of a sudden, you got an issue in the middle of the night. If you hired a bonded, licensed, insured plumber, at least you'd be covered on the rear side. And then the third thing is almost always err on the side of disclosure, because what you don't say, omission, can be as bad as what you do say, and sometimes even worse. Anything else you'd like to throw in, Bear?
no, I think you covered it, Michael. We've covered a lot of ground here. Obviously, we covered it in a general sense, but we didn't get down to the specific granular aspects. But I know you were kind enough to put my contact information in the crawl, and anybody who's got
Absolutely.
questions or concerns, feel free to get in touch with me. I'll be happy to speak to you and let you know if there's anything you need to do or anything I can do for you. But all my thanks and gratitude for inviting me to be on the show, Michael. It was a great time.
And right back at you. Thank you very much. And for the audience, we appreciate your tuning in. We appreciate your time, your attention. We hope that we've given you a little bit of guidance and information that may make your life easier down the pike. Never be too proud to ask a question. You're always welcome to do so, and we're always happy to answer. That's why we are at your service on this show. We'll look forward to seeing you next week for episode number 60. And Barry, thank you very much again for coming. I hope you'll come back and join me another time.
Anytime, Michael. Anytime.
Take care, y'all. Our producers will be putting this up on YouTube. We'll get it spread out across social media, and I will send links up on my social media as soon as possible. Thank you all again. Have a great day. Thank you, Barry. Appreciate you. See you soon.